Hi, I'm Neal Fugate. In this series of videos, I want to give you a really strong understanding of the Residential Purchase Agreement, or the RPA. And the RPA is the contract between a buyer and a seller for a residential real estate transaction. If you'd like a sample copy of the RPA, then I'll leave a link for that below. In this first video, we're going to go over Form AD, which is the disclosure regarding real estate relationship. When you're presented a packet from your realtor, then there's going to be a number of other documents included as well as the RPA, and this is the list. Form AD is top of the list because normally this is going to be the first document that you sign when you're working with a realtor. It actually clarifies and explains the types of relationships that an agent can have with each party involved. And it also outlines the agent's responsibilities to those parties. A seller's agent acts as the agent for the seller only and has certain obligations to the seller. A fiduciary duty of utmost care, integrity, honesty, and loyalty in dealings with the seller. They also have obligations to both the buyer and the seller. Those are diligent exercise of reasonable skill and care in performance of the agent's duties, a duty of honest and fair dealing and good faith, a duty to disclose all facts known to the agent materially affecting the value or desirability of the property that are not known to or within the diligent attention and observation of the parties. Basically, that means if the agent happens to know something that neither the buyer or the seller is aware of about the property, that it's their duty to disclose it. But at the same time, an agent is not obligated to reveal to either party any confidential information obtained from the other party that does not involve the affirmative duties set forth above. A buyer's agent can, with the buyer's consent, agree to act as the agent for the buyer only. And in these situations, even though the agent isn't the seller's agent, even if by agreement the agent may be receiving compensation for services rendered, either in full or in part from the seller. So in a normal real estate transaction, the buyer's agent as well as the seller's agent is paid after escrow is closed from the proceeds that are given to the seller. Even though, in effect, the buyer's agent is working for both parties and working for the seller because he's being paid by the seller, his primary duty is to the buyer. And in that regard, the buyer's agent has a fiduciary duty of utmost care, integrity, honesty, and loyalty in dealings with the buyer, and the other obligations that the seller's agent has to both parties as well. In some cases, an agent can represent both seller and the buyer, and this can be done only with the knowledge and consent of both the seller and the buyer. This is called dual agency, and the agent has the following affirmative obligations to both seller and buyer. A fiduciary duty of utmost care, integrity, honesty, and loyalty in dealings with either the seller or the buyer. And the other duties that we've already covered that any agent always has for both parties involved. In addition to that, in the case of a dual agency situation, the agent cannot disclose anything that was shared by either party with the agent that was disclosed in confidence that may affect the bargaining position of either party or their motivations. For example, if a buyer discloses to the agent that they're willing to pay more than the price that they've originally offered, the agent can't share that with the seller. And likewise, if the sellers disclose something to the agent, such as they would be willing to take a lower price for the property, the agent can't disclose that to the buyer. It would be violating the fiduciary duties that the agent has to both parties. And something else to keep in mind is that it doesn't have to be the same agent representing the buyer and the seller for dual agency to apply. And I'll cover that in this side note. For instance, if an individual agent is working for a specific brokerage and they're representing the buyer, and the seller's agent is also with that same broker, they're representing the seller, and a transaction is agreed upon, then that's dual agency. Because even though the agents may not know each other, they may never have heard of each other, and they could feasibly work in different offices that are both under the same broker, because they're with the same brokerage, it's dual agency. That's just something to keep in mind moving forward. It's fairly common, but it is dual agency nonetheless. And if you would like more information about dual agency in general, then I'm going to leave a link for the dual agency disclosure guide below, and you can download that as well. So we now know that the agents have certain responsibilities and duties to the buyers and sellers. But sellers and buyers also have responsibilities. As a buyer or seller, you need to understand how you're being represented. It's spelled out in the contract, but if you don't understand your agent's role, you need to make sure that they clarify it for you. And even though an agent is representing you in a real estate transaction, it does not relieve a buyer or a seller of the responsibility to protect their own interests. So a buyer or a seller needs to carefully read all the agreements and make sure that they adequately understand the transaction that they're becoming party to. A real estate agent is a person qualified to advise about real estate. It's also incumbent on the sellers and buyers that if they require additional information that isn't in the realm of expertise of a realtor, that they get it on their own. For instance, legal or tax advice. Realtors, we're not allowed to share our opinion on that because it's outside our realm of expertise. So it's a seller or buyer's responsibility to reach out to other qualified professionals if they feel like they need that kind of information. Also, there may be other realtors involved in the transaction, either for the buyer or the seller. If that's the case, then they will also need to complete an AD, and that their relationship to whatever party they are representing should be clear to you as well. Page 2 of Form AD contains all the details of the civil code sections that are referenced on page 1. And you'll want to go through this as well so you understand everything to your own satisfaction. But keep in mind that this page doesn't require a signature. Your signature on page 1 acknowledges that you've received this information as well. Thanks for watching Understanding the RPA Part 1. If you have any other questions about Form AD, please don't hesitate to let me know. I hope that this has given you a better understanding of what to expect when you go into a real estate transaction. And remember, I'm going to leave a link so you can download your own sample copy of the RPA packet whenever you want. In the next video, I'm going to cover the PRBS and the WFA. The PRBS is the possible representation of additional buyers and sellers, and the WFA is the wire fraud advisory form. So if you have any questions before then, as I said, don't hesitate to let me know. As always, I'm here to help. Thanks.